Most constitutional scholars agree that even an official act that is enumerated by the Constitution can give rise to impeachment.
Well, that pretty much sums up the crux of the entire impeachment debate. Viva Frei, Montreal litigator turned YouTuber, and the other day, the other YouTube lawyer, Legal Eagle, put out a very long 38-minute thorough analysis of what he referred to as the the Steel Man argument. Legal Eagle referred to his presentation of the opposing views as the Steel Man argument as opposed to the Straw Man argument, insofar as he was going to do his best to do justice to all the arguments in opposition to the impeachment inquiry.
I'm going to try to give the Republican defenses in the best light possible to avoid attacking straw men and dealing with the best possible version of those particular defenses.
But in one statement he made some 25 minutes into the video, Legal Eagle essentially inadvertently admitted why the entire analysis of the purported Steelman arguments was utterly useless and pointless from the beginning. Based on the opinions of scholars, according to Legal Eagle, it doesn't even matter if what Trump did was entirely legal and indeed provided for in the Constitution, it can still serve as the basis for an impeachment.
Most constitutional scholars agree that even an official act that is enumerated by the Constitution can give rise to impeachment.
And the bottom line about that is that he's not actually wrong. When it comes to impeaching a president, the high crimes and misdemeanors that serves as the basis for the impeachment is whatever Congress says it is. But we'll get there. For the time being, I'm going to go through Legal Eagle's video, discuss some of the alleged Steelman arguments he raised in opposition to the impeachment inquiry, and illustrate that they were not in fact as Steelman presented as he purported they would be. Let's start with the first one.
It does seem like most Republicans are pivoting away from the argument that there is no quid pro quo at all, because to believe that argument, you would have to believe that most of the witnesses that have testified so far are lying, including Yovanovitch, Salman, Holmes, Williams, Taylor, Volker, Kent, Hill, Vindman, and John friggin' Bolton.
Alright, this tactic is akin to the shock and awe, which is you bombard a viewer with so much information that you know they will not be able to verify at the time, in the hopes that they will not independently verify it afterwards. The argument here is that opponents to the impeachment process are going to start shifting the argument from there was no quid pro quo to there was no impeachable quid pro quo. Because in order for them to affirm that there was no quid pro quo, we would have to call all of these witnesses liars. That is in fact not a Steelman argument, but rather a straw man argument, for the following reason. A lot, if not all of the witnesses that Legal Eagle just blasted off one after the other were either testifying on the basis of hearsay or their personal beliefs as to what occurred. You don't have to call someone a liar in order to conclude that they were mistaken in their belief, nor is someone who is in fact mistaken in their belief necessarily a liar. In today's day and age, we sort of erroneously equate being wrong with being a liar. And the two are fundamentally different. Somebody can be wrong and somebody can have the wrong beliefs without necessarily being a liar. Someone can tell you something that is factually incorrect and they may be wrong but not necessarily a liar. And those witnesses cited by Legal Eagle testified by and large to their personal beliefs as to what occurred or hearsay evidence as relates to the quid pro quo. So much so that Legal Eagle did an entire video explaining what hearsay was, its probative value, so that we should afford more probative value to the hearsay evidence presented by those very witnesses. So no, it's not true that in order to conclude that there was no quid pro quo, we have to call all of these witnesses liars. They can be mistaken in their beliefs, or we could just disagree with their conclusions of opinion. And the other aspect to this argument is that it may be an issue of semantics. Calling it no quid pro quo versus no impeachable quid pro quo might very well mean the same thing to most people. To the extent that from the very beginning of this scandal, prior to the term being shifted to bribery, people were using the term quid pro quo to describe a high crime or misdemeanor sufficient to impeach a president. And so when people say that there was no quid pro quo, it's not necessarily to deny the fact that there was some negotiation in foreign relations, but they mean it tantamount to say that there was no impeachable quid pro quo in the sense of a high crime and misdemeanor. That would be the argument, that when one says there was no quid pro quo, it is just shorthand for saying there was no impeachable quid pro quo. People need to remember this for the future. Being wrong does not make you a liar. Having a mistaken belief does not make you a liar. That said, affirming something that you know to be false or have no reasonable basis to believe to be true is a lie, and that is different than saying, I believe X from a series of facts. And that is what the witnesses did.
Which is why it seems to appear that most Republicans have moved on from no quid pro quo to no illegal or impeachable quid pro quo.
We do that all the time with foreign policy.
And in fact that this particular quid pro quo was conditioned partially on an investigation into the Bidens.
Alright, that's not a Steelman argument, that's a straw man argument. Why? When Mick Mulvaney said, quote, we do this all the time, the quid pro quo, it was not in response to an investigation into the Bidens, it was in response to an investigation into the Democratic servers.
To be clear, what you just described is a quid pro quo. It is funding will not flow unless the investigation into the Democratic server happen as well.
We do that all the time with foreign policy.
A quid pro quo for an investigation into the Democratic server is not the same thing as a quid pro quo into an investigation of the Bidens, as Legal Eagle purports Mulvaney admitted. Depending on what's in those servers, it may indirectly relate to the Bidens, but when Mick Mulvaney said there's a quid pro quo, we do this all the time, it was not, as Legal Eagle said, in respect of an investigation into the Bidens.
Gordon Sondland said in his testimony that there was, in fact, an explicit quid pro quo. He straight out said it.
Was there a quid pro quo? As I testified previously, with regard to the requested White House call and the White House meeting, the answer is yes.
All right, and we're going to come back to this later because when Gordon Sondland in his opening testimony says that there was in fact a quid pro quo, and then later on asserts that he asked Trump on September 9th what he wanted, and Trump said there was no quid pro quo, there's a timeline discussion here that is in fact relevant, and we'll get to it later. For now, there's a bigger point coming up right now.
And as Neil Katyal has argued on Twitter, the only reason that we don't have the first-hand knowledge witnesses is because Trump blocked them from testifying. That itself is impeachable. That itself is impeachable.
Okay, now I'm reading this tweet to look for the portion that says that blocking witnesses from testifying is itself an impeachable offense, and I didn't see it in the tweet. In fact, it appears to be Legal Eagle suggesting that blocking witnesses from testifying is itself impeachable. I talked about this in one of my previous vlogs, I'll link it right here, give it a watch. There is a 2014 OLC memo, the Office of Legal Counsel memo, that specifically confirms that the president can block witnesses from testifying on the basis of executive privilege. Now, building an actual Steelman argument, there is some discussion as to whether or not this applies to witnesses in the context of impeachment hearings. There is some discussion and potential disagreement about that, but as it currently stands, this 2014 OLC memo, drafted under the Obama administration, confirms that the president can block witnesses on the basis of executive privilege. The most beautiful thing about any debate is when you come to the fundamental point of disagreement, after which point there is no point discussing the issue anymore. This 2014 memo confirmed that the president can block witnesses on the basis of executive privilege. And this video started off with Legal Eagle affirming that even if the president's conduct is provided for in the Constitution, it can nonetheless serve as the basis for an impeachment. So there really is no winning. Here, Legal Eagle says that blocking witnesses can itself be an impeachable offense. There's a 2014 OLC memo that says otherwise, but Legal Eagle also says that even doing that which you're allowed to do can serve as a basis for an impeachment. But in building and responding to a legitimate Steelman argument, one does have to answer the question as to why the president would block certain witnesses with first-hand knowledge from testifying. And in my previous video, I jokingly said that if you've got nothing to hide, you've got nothing to worry about. That is not necessarily true when one is strictly looking for guilt and not truth. I say this with no political affiliation and no spin, purely as an outside observer. From day one of Trump's presidency, people have been calling for his impeachment. I can think of multiple incidents which probably would have been innocuous under any other presidency where people were reflexively clamoring for impeachment. So you can hate him as much as you want, but you can't blame Trump for having suspicions that the purpose of this impeachment inquiry is not to get at the truth, but to get at the impeachment. And in which case, much in the same way when you're being arrested by an officer, you're probably better off just being quiet because nothing you're going to say is going to convince the officer not to arrest you. All you can do is say something that the police officer is going to try to use against you. Agree or disagree with it, in his mind, he has absolutely nothing to gain from cooperating with the impeachment inquiry because in his mind, they are not after the truth, they are after an impeachment that they have been clamoring for since the first day he was elected.
Which brings me to the next big defense, which is that the aid, the military and financial aid that was allegedly conditioned on investigations into the Bidens, was in fact released. Along those lines, Nikki Haley says it didn't succeed, so it was absolutely okay.
The Ukrainians never did the investigation, and the president released the funds. I mean, when you look at those, there's just nothing impeachable there.
It didn't succeed, so it was absolutely okay.
Again, not a Steelman argument because that's not what Nikki Haley said. Nikki Haley did not say or suggest that because the quid pro quo didn't succeed that there was nothing there. What she said is that the elements of what people are describing as a quid pro quo didn't exist so as to undermine the existence of the quid pro quo itself. The way Legal Eagle is framing the question is sort of that classic joke of a question, so when did you stop abusing your dog? The formulation of the question presupposes the guilt and there's no way to respond to that question without admitting the guilt. If we're building a Steelman argument, swap the word quid pro quo with bribery. Does anyone actually interpret this particular clip as Nikki Haley saying the bribery didn't succeed so there's just nothing there? What she is in fact saying is that the elements of the purported bribery don't exist to undermine the allegation of bribery itself. And it is a very subtle yet insidious spin on the answer that Nikki Haley gave. She did not admit the quid pro quo. She is saying that the elements weren't there to deny the accusation itself.
The aid was released only after Politico did its famous article on this particular potential quid pro quo, after the whistleblower had already come forward, and after the House had started investigating the whistleblower, that based on that timing, the actual release of the funds is not as exculpatory as the administration may want it to seem.
All right, and this is a very legitimate point that even opponents of the impeachment inquiry have to acknowledge. And the same argument holds true for Gordon Sondland's testimony to the effect that Trump confirmed to him, no quid pro quo, I just want Ukraine to do the right thing. The timing of the release of the funds and Trump's potentially self-serving affirmation, no quid pro quo, is after the whole scandal broke to some extent. Politico had written an article to the effect that the funds were being withheld and nobody knew why. Prior to the release of the funds, the whistleblower complaint was apparently filed or received, and an internal investigation had already begun. And so one can't disregard the idea that if this information in fact found its way up to the president, that the first thing they would do would in fact be to release the funds and then issue as many self-serving statements as possible. And some might be prepared to acknowledge that it was in fact in response to the scandal that was brewing, but there was nothing illegal in it from the beginning. Others might argue that it was either coincidental or the necessary timeline as a result of how the funds had to be released before the year end. But again, this is going to be one of those situations where we all agree on the facts and the timeline, we just disagree on how to interpret those facts. And as I'm going to repeat multiple times throughout this video, according to Legal Eagle, it doesn't even matter if it was entirely lawful, it can still nonetheless serve as the basis for impeachment. In which case the entire discussion is academic. Either it was illegal and therefore impeachable, or it wasn't illegal and yet still impeachable. Moving on.
And as far as I know, there doesn't appear to be a strong counter-narrative as to why the aid was held in the first place. The best defense is that it was somehow related to anti-corruption measures, which we'll talk about in just a second.
As far as he is aware, there doesn't appear to be a strong counter-narrative for why the funds were withheld, and then in the next breath he explains exactly what that counter-narrative is.
Steelman argument?
You keep using that word. I don't think it means what you think it means.
Now some, including Mick Mulvaney, have argued that the president withheld the aid to ensure that it was put to good use. But it's worth pointing out that the president doesn't have authority to withhold congressionally appropriated funds. And the funds would have expired if not released by the end of September because of the way that the congressional budget works. And it wasn't until almost the entire year after it was passed that the Trump administration actually released the appropriated funds.
Okay, if we're truly building a Steelman argument, it is true that the president can withhold funds for a limited period of time, but it is also true that the OMB, the Office of Management and Budget, can refuse to allow the release of those funds under certain conditions. And Mick Mulvaney, in his capacity as director of the OMB, could, in theory, have refused to authorize the release of the funds despite the fact that they had been appropriated by Congress. And again, in building a legitimate Steelman argument, the question is obviously going to be, just let Mick Mulvaney testify then. Let Mick Mulvaney testify as to why the OMB withheld the funds until September 2019. Let Mick Mulvaney explain why they ultimately released the funds. But the Steelman argument being a two-way street, you gotta go back to the argument I raised earlier that the Trump administration might not necessarily see this impeachment inquiry as a pursuit of the truth, but rather as a pure pursuit of an impeachment. In which case, it can be argued that you have absolutely nothing to gain by allowing Mick Mulvaney to testify because no one's after the truth, they are after a soundbite or one little iota of evidence to support the sought-after impeachment.
This is what happens when government becomes dysfunctional.
And he focused on the idea that because the Ukrainians didn't pay up for what was part of the quid pro quo, that therefore there was no underlying crime.
You know what a quid pro quo is?
I do.
This for that, right? Looks to me like Ukraine got that 3 times, and there was no this. We didn't do anything. Or excuse me, they didn't have to do anything.
The argument goes that effectively no harm, no foul, because the Ukrainians got what they wanted, and they didn't have to investigate the Bidens.
Again, this is the same mischaracterization that Legal Eagle did with Nikki Haley. If we are truly trying to understand the purpose of Jim Jordan's examination, it is not to suggest that the quid pro quo request was made but never satisfied, therefore no harm, no foul. The purpose of Jim Jordan's questioning is to illustrate the fact that the essential elements of any quid pro quo never existed in fact, so as to undermine the allegation of the request for a quid pro quo in the first place.
Impeachment is a political device, and high crimes and misdemeanors can often mean whatever Congress says it means.
High crimes and misdemeanors means whatever Congress says it means because this is not a legal process, this is a purely political process. As one of my extremely democratic and highly educated friends jokingly told me, if Congress decides they don't like the color of Trump's underwear, they can make that a high crime and misdemeanor. Now that is a reductio ad absurdum, and while it may in theory be true by the strictest letter of the law, society as a whole would not put up with impeaching a president for the color of his underwear. But it remains true that high crimes and misdemeanors for the purposes of impeachment means whatever Congress says it means. It doesn't even have to be illegal, which is why all of this argument as to whether or not it was bribery, an illegal quid pro quo, is absolutely irrelevant at the end of the day.
Gordon Sondland says that after Bill Taylor famously texted, "As I said on the phone, I think it's crazy to withhold security assistance for help with a political campaign," in a September 9th phone call with the president that potentially raises the questions that Bill Taylor raised.
I just asked him an open-ended question, Mr. Chairman. What do you want from Ukraine? I keep hearing all these different ideas and theories and this and that. What do you want? And it was a very short, abrupt conversation. He was not in a good mood. And he just said, I want nothing. I want nothing. I want no quid pro quo. I just asked him an open-ended question, Mr. Chairman. What do you want from Ukraine?
So there's a very interesting thing here about this timeline itself as well. A lot of people rightly pointing out that Trump's no quid pro quo came after the whole story broke, and so it was a cover your butt as opposed to an authentic sort of no quid pro quo. The interesting thing is that Bill Taylor's text to Gordon Sondland also came after the entire story broke. For those of you who may not be aware of this, on September 9th, 2019, Bill Taylor now famously wrote to Gordon Sondland, "As I said on the phone, I think it's crazy to withhold the aid for help with a political campaign." As I said in one of the previous videos where we were talking about the impeachment, whenever someone starts a written correspondence with "as discussed," "as mentioned" over the phone, it is either a cover your butt correspondence or a throw you under the bus correspondence. And now knowing that Bill Taylor was writing this after the entire story broke, one can question what the purpose of that text was. One can look at Gordon Sondland's response, "No, Bill, you're misunderstanding, there is no quid pro quo," and try to reconcile that with Gordon Sondland's testimony before Congress. In his testimony, he says that everyone knew about the quid pro quo.
You've testified that Mulvaney was aware of this quid pro quo, of this condition that the Ukrainians had to meet, that is, announcing these public investigations to get the White House meeting. Is that right?
Yeah, a lot of people were aware of it, and
including Mr. Mulvaney.
In his text, which he wrote after the story broke, he says, "You're misunderstanding, there is no quid pro quo." And then despite all of this, he goes and asks President Trump an open-ended question, to which Trump responds, "No quid pro quo." These are the facts. How one interprets them is purely up to their discretion and judgment.
Next potential defense, which is that the president controls foreign policy and it would be improper to impeach him over a foreign policy decision. Now, there is certainly some truth to this. The president has almost all of the power for foreign policy. Now, there is a dispute about whether a constitutionally enumerated power can give rise to a crime or to impeachment.
Well, when the president does it, that means that it is not illegal, by definition. Exactly.
And this is by no means a steelman argument. This is yet another strawman argument. Nixon is not saying that whatever I do in virtue of the Constitution is therefore legal. What Nixon is saying is whatever I do as president is therefore legal because I am president. That is fundamentally different than saying when I carry out one of my duties that is specifically provided for in the Constitution, it is necessarily legal. There is a dispute as to whether or not a constitutionally enumerated power can give rise to an impeachment. Okay, that is far different than Nixon saying whatever I do as president is legal because I am president. But to color the situation, that video clip is absolutely inapplicable to the prior statement.
Most constitutional scholars agree that even an official act that is enumerated by the Constitution can give rise to impeachment, if not criminal prosecution. But just because you have a right doesn't mean that you can escape the repercussions of exercising that right. In the same way that you have a First Amendment right to freedom of speech, but that doesn't absolve you from all of the repercussions of actually using that speech in a specific way.
This is an absolutely flawed analogy because the precise situations in which one gets sanctioned for freedom of speech is when it violates the legally established principles and limits on freedom of speech. And we are also not talking about the contextual limits of freedom of speech, for example, things you can say at work, or the social repercussions of freedom of speech. If you insult people, sure, you're going to suffer consequences. It's something I always say, we don't need to argue from an imperfect analogy when we have a perfect example. Can the president be impeached for exercising his constitutional authority? Legal Eagle is saying that there are scholars that say yes. And when we understand that high crimes and misdemeanors means whatever Congress wants it to mean, we can envision situations where Congress can impeach for constitutional authority because it deems it to be a high crime and misdemeanor. There may be heck to pay on a social upheaval level, but in theory it is possible. But we need to address the specific issue of pardon that Legal Eagle raises right now.
In the same way that the president has almost unfettered foreign policy power, the president absolutely has unfettered pardon power. It can't be checked by Congress, and it can't really be checked by the judiciary either. But if a president started selling pardons for $1 million apiece, that president could, and pretty much by all accounts should, be impeached for that kind of action, despite the fact that the president is allowed to pardon people under almost any circumstances.
The president has the constitutional authority to pardon whomever they want. But if they start selling those pardons for $1 million a pardon, they should be impeached and possibly imprisoned. Okay, but that is not a steelman argument, that is a strawman argument. In a sort of intellectual sleight of hand, Legal Eagle here is coupling an actual crime with an actual presidential authority. And nobody would deny the fact that the president can't use their constitutional authority to commit a crime. An appropriate steelman argument of an analogy, let's just say that hypothetically a president exercised their presidential authority to issue pardons to the most violent, over-the-top, egregious criminals. Here we have an example of where a president can use their presidential authority in a manner that is not itself illegal, but in a manner that itself might lend to impeachment for high crimes and misdemeanors.
Which brings me to the next potential defense. The president has a duty to root out corruption both domestically and abroad. I think that this is probably the main defense that we're going to see going forward. If someone has committed the act that is sufficient for a crime and has multiple reasons for doing it, one of which is the mental state that's required for the criminal offense, the fact that there are multiple different motivations is irrelevant. If any one part of that motivation is sufficient, that person can be convicted.
Alright, and another intellectual sleight of hand. Following the analogy, if President Trump did in fact commit a quid pro quo, but one of the reasons was to legitimately root out corruption, and the other reason was to illegitimately get dirt on a political rival, he could nonetheless be impeached. But that presupposes that the reasons are cumulative and not alternative. The real question here as relates to the impeachment is not going to be did he do it both for rooting out corruption and getting dirt on Joe Biden. The question here is going to be did he do it for the otherwise legitimate purpose of rooting out corruption, or did he do it for the illegitimate purpose of getting dirt on a political rival? And this is how Legal Eagle is framing Trump's defense. I did it to root out corruption, but he may have also done it to get dirt on his political rival. Whereas the defense is presumably going to be I was doing it to root out corruption, not to get dirt on a political rival, and if the one happened to overlap with the other, that's not my fault. And so what do we make of all of these purported steelman arguments? It doesn't actually matter.
It just doesn't matter! It just doesn't matter! It just doesn't matter! It just doesn't matter!
There was no quid pro quo. If there was a quid pro quo, it wasn't illegal and it was within the president's authority. From the pro-impeachment side, there was illegal quid pro quo or bribery. If there wasn't bribery, there was abuse of power. If there wasn't abuse of power, there was at least improper use of power. If there wasn't improper use of power and everything the president did was within his constitutional authority, they can still impeach him because the fact that it was constitutional doesn't mean that he can't get impeached for it. And now you have your steelman argument of both sides. If you like this video, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below, and now you know your vlog. Peace out. Booyah!